This case right here is not just another DUI, it's a ticking time bomb that's already gone off multiple times. We're talking about a defendant standing in court for her fifth DWI, and somehow, she's still questioning it. That alone tells you everything about what's about to unfold. Now think about this. Every time someone drives under the influence, they're not just breaking the law, they're gambling with lives. And the judge makes that crystal clear when he refers to vehicles as 4,000-pound missiles. That's not exaggeration, that's reality. But here's where things get even more intense. The defense tries to shift the focus toward health issues, sympathy, and even a reduced sentence. Meanwhile, the judge is focused on one thing: pattern behavior. That not one mistake, not two, but repeated decisions that could have ended in tragedy at any moment. So the real question is, how many chances should someone get before the system says, enough is enough? And when sympathy meets public safety, which one should win? Stay with this case, because what happens next is a powerful breakdown of accountability, consequences, and a judge who refuses to ignore the bigger picture.
This is your fifth DWI, ma'am. You're saying it's not. So you have money, then you can avoid being held responsible? Why do the rich people get treated differently? I thought that we were all treated fairly under the law. All right. This is case number 25 CR441. You are Tammy Dunaway Jadis.
Correct.
Excuse me. And you were with Mr. Adams, your attorney, and the state's attorney. Earlier, you pleaded guilty to operating a motor vehicle while intoxicated, but this is a third-degree felony because you pleaded true to the second paragraph, which included allegations of 4 prior DWI convictions dating back to 2007. And paragraphs 1 and 2 constitute a third-degree felony, so you were facing up to 10 years in prison. The agreement is whatever sentence shall not exceed a cap of 6 years in prison, so you're looking at no less than 2 nor more than 6 years in prison. And you could be convicted, sentenced to up to 6 years in prison. That could be suspended and you could be placed on probation. And deferred or unadjudicated probation is
On what case?
DWI thirds not allowed. So it's a conviction.
Deferred, yeah.
Sir?
You can't do deferred, I don't think.
No, that's disallowed for driving while intoxicated cases.
Right here, the judge lays out something extremely important, and this is where a lot of people misunderstand how the legal system works. Once you reach this level, a third-degree felony DWI, your options shrink dramatically. Probation, not available in the way many expect. Deferred adjudication, off the table. This is no longer about learning a lesson. This is about punishment and protection of society. And notice how clearly the judge explains the sentencing range: 2 to 6 years under the plea cap. That means the defendant is no longer negotiating freedom. She's negotiating how much time she's going to lose. Let me ask you, do you think repeat offenses like this should automatically lead to prison time? Or should there still be room for leniency, especially when health issues are involved? That's because the court right now is weighing 2 things: compassion versus community safety, and that balance is about to tip.
Cases. So that's what we are looking at. A pre-sentence report has been prepared. Have the parties had an opportunity to review it, and are there any corrections or changes to it?
I've reviewed it. I don't have any objections, but let me give you this. I wanted to add something to it. I brought this to the probation officer 2 weeks ago, which was a week ahead of the hearing, the first hearing. This was supposed to be heard last Friday, and I brought it 2 Fridays ago, and somehow it didn't get into it. But it's just medical proof that she has a pretty serious osteoporosis weakness of the brittleness of the bones. She's broken her hip. She's been on a walker. It'll probably be the rest of her life.
But yet she can still drive a 4,000-pound missile.
Evidently, yes. But I said,
I haven't been able to, sir, at all.
Since when? Well, we know in October 2023 you were.
No, I mean,
That's when you were caught
Yes.
in the DWI.
but I have not driven since when I had my accident, December
of 2025, of 2024.
or 2023, same year.
This is
No,
the
that's
turning point, and you can feel the judge's tone change instantly. When a defendant doesn't even fully acknowledge their own criminal history, it raises a massive red flag, not just legally, but psychologically. The judge literally says, "I know more about your criminal history than you do." That's powerful, and honestly, a little alarming, because in court, accountability starts with awareness. If someone doesn't recognize the full extent of their past actions, how can the court trust that they'll change in the future? And here's the deeper issue. This isn't just about numbers. Each one of those DWIs represents a moment where lives were at risk. And yet, the defendant is still downplaying it. So let me ask you, do you think this is denial, confusion, or avoidance? Because whatever it is, it's not helping her case.
No, that's not the real problem. The problem is this is your fifth DWI that we know about.
Fourth.
No, man, you got 4 prior convictions. In May 31st, 2007, County Court of Law 3 of Jefferson County, you were convicted to operating a motor vehicle while intoxicated. After that, on August 27th, 2008, which would be a little over a year later, in County Court of Law 3, another operating a motor vehicle in a public place while intoxicated. Then a little over 4 years later, on December 3rd, 2012, you picked up 2 cases. You were convicted of 2 cases in cause number 907764 and 12-15124 out of the 252nd District Court next door. Those were 2 separate DWIs.
Yeah, she was,
that were handled in the same proceeding, but this is your 5th DWI.
yeah, the 4th one, Your Honor, was used to revoke her probation on the 3rd. And that's why they were both the same day.
I know that's still bad.
Yeah, no,
I mean,
not,
but here's the problem. This is the problem. She's standing there,
yeah.
but is not appearing coherent. I know more about her criminal history than she does. This is your 5th DWI, ma'am. You're saying it's not. We got to resolve that first. You should know more about your life than I should ever.
Right.
But why are you saying this is your?
I didn't think it was, sir. That's the God's truth.
Well, I think there's some mental problems here.
Or
I think there's some mental problems here. I mean, what's the state say? Or do we have 4 separate prior convictions of DWI?
Yes, Judge, we do.
okay.
You want me to show them to you?
No, believe me.
But I shouldn't have to be trying to convince you. This is your life.
Well,
You should be more intimately familiar with your mistakes than me.
I know how many times I got arrested.
Ma'am?
I know how many times I got arrested. Arrested.
That's not a conviction. Being arrested, that's probable cause that you might have done something wrong, but you're presumed innocent unless you're found guilty. That's what's important for convictions. It's not a good deal to be arrested for whatever reason. That needs to be fixed, but until you're found guilty, or unless you're found guilty, we're not talking about any other arrests. We're talking about convictions here in this.
Okay.
And that's what sentencing is all based upon, criminal history of convictions and the circumstances of this crime. And it's DWIs that's your only criminal history, but you got, what's that? This last time they gave you a break on your third, you were given a break. You were placed on probation, and then that was revoked with another DWI.
Now, the judge
Then-
breaks down one of the core principles of criminal law, escalation of consequences. And this is something a lot of people overlook. The system is designed so that every repeated offense brings more severe punishment, not less. Why? Because if penalties stayed the same or got lighter, there would be zero deterrence. And the judge says it plainly. You don't get rewarded with leniency for continuing the same behavior. This is where the defense strategy starts to fall apart. They're asking for less time because of health issues, but the court is looking at a pattern of behavior that's only getting worse. So here's the question for you. Should personal hardship reduce punishment, even when someone keeps making the same dangerous decision over and over again? Because right now, the judge is making it clear, public safety comes
Both
first.
with another DWI. And then you were sentenced to 5 years in prison, right?
Correct.
Okay. But you understand the way things happen is when you commit further or subsequent criminal behavior in the same subject matter, the penalties go up. You don't get less punishment for subsequent behavior of the same type. Do you understand?
Right.
All right. I just wish you'd make the right decision when you get into a 4,000-pound missile. It does terrible tissue damage when it hits humans in collisions.
Yes, sir.
We have this every day. We have to deal with tragedies in this room on misuse of motor vehicles. I'm looking at what was presented. I guess, Frank, you presented this from Diagnostic Health.
Yeah, yes, sir.
Okay.
And I gave it didn't get in her report, but I brought it to her 2 weeks ago, which is the week ahead of when we were supposed to be here the first time. But it's showing that she does have a pretty serious osteoporosis. She's had a broken hip and what else?
Broken back, broken shoulder, and broken knee.
And she doesn't walk hardly anywhere except her home. She doesn't go to the grocery store or anything like that. And she'd even be willing to, but she even going to probation would be difficult, and she doesn't want probation. What she'd like, Your Honor, and I know it's kind of unusual, is 2 years jail time, and she'd pay a $5,000 fine, and you could even add safe fee. She's never gone to drug treatment or anything ever, or alcohol treatment. She's not an addict, she's an alcoholic.
Well, how do I put her in safe P, substance abuse felony punishment when she goes to prison?
That is prison.
No, that's a condition of probation. That's the
Well,
way we do that. It's safe P is not supposed to be
she doesn't, yeah.
punishment. It's a medical facility, but that's not a condition under the statute when you get, if
But
they
she-
want to send her,
Yeah.
if the state of Texas wants to send her to a facility, I guess I can't stop that as part of her confinement, but I can't order it and then
Yeah.
place her in prison. But also the problem is, Frank, is it defies logic and the historical significance of the way the criminal system works. You don't get less punishment for the same subsequent misbehavior. What kind of deterrence aspect is that? It's supposed to deter people by more punishment each time you make the same wrong choice.
Well, because of her health issues, Your Honor, she's willing, if you'd give her 2 years jail and she'd have voluntarily pay a $5,000 fine only because of her health concerns or concerns for her. That's the unusual circumstance. I understand that each time you commit a DWI, you don't get less punishment.
Well, that's what y'all are proposing. 2 years in prison is less punishment than we had last time.
But you'll pay a fine of $5,000. Let's say finally at least make some money.
Here's what's
This
fair is
moment.
fair.
This is one of the most powerful statements in the entire case. The judge calls out something that a lot of people think, but rarely hear said out loud in court. So if you have money, you can avoid responsibility? That's a direct challenge, not just to the defense, but to the idea of fairness in the justice system itself. Because what's being proposed here is essentially this: reduce prison time, but increase the fine. And the judge immediately pushes back, because justice isn't supposed to work differently based on your financial status. This is bigger than just one case. This is about equality under the law. So let me ask you, do you think wealth should ever influence sentencing outcomes? Or should punishment remain the same, no matter who you are? Because right now, the judge is making one thing very clear: justice is not for sale.
What's fair is fair. Just because somebody can pay a fine, most people in here can't. So you have money, then you can avoid being held responsible. I mean, if I was a poor person, I'd say, I don't have that kind of money. Why do the rich people get treated differently? I thought that we were all treated fairly under the law.
Well,
And that's the way I kind of believe it should be.
I agree with you, Honor,
Okay.
but her health issues are the other factor need to be factored in, and that's why I brought the medical.
Mm-hmm.
And then she's got, she's on a walker. She's got osteoporosis, which is pretty serious thing, and she could just break a bone, not just falling or something.
Okay, but she can still drive a car.
No, not like that. I've been able to drive.
She'd surrender her license if she could,
Okay. Well, we know you were driving one October 19th of 23.
Yeah.
And then after that, you got sick?
I failed.
You weren't ill before that?
No, I failed.
This is where the case becomes less about law and more about human behavior.
Is the next
Isn't
question
just looking at the charges anymore. He's asking a deeper question. Why does this keep happening? 5DW isn't just a legal issue. It signals a pattern that hasn't been corrected despite multiple opportunities. And the judge highlights something crucial. Probation didn't work. Prior prison time didn't work. And even prior convictions didn't stop the behavior. That's why you hear frustration in his voice. Because at this stage, the court is no longer trying to prevent a mistake. It's trying to contain a risk. And here's the reality. When someone repeatedly makes dangerous choices, the system shifts from rehabilitation to protection. So think about it. How many chances should someone realistically get before the court says, "We've tried everything"? Because for this judge, that limit has clearly been reached.
That begs the question, really. There's a problem when you commit 5 DWIs, man. There's a problem there. And this osteoporosis has just come up after your 5th DWI. How can you explain the misbehavior and the wrong choices?
It was wrong.
How many wrong mistakes do you have to make to do something about it? We even tried to help you with probation, and that was revoked because you got another DWI.
Right.
Wow, probation. Okay. All right. Okay. All right, what's they say?
Looking over the PSI, Judge, I think what strikes me the most is that the defendant has minimized her responsibility Until today. It was refreshing a little bit to hear her say, take responsibility. I was wrong.
Okay.
She minimized her responsibility throughout the investigation. Also, the
But
amount
she's doing it today.
today. That's correct.
I guess it's never too late to
Mhm.
make an act of contrition.
Mhm. Also, the number of prior DWIs is a factor. The safety of the community is a factor. The fact that she's already served 5 years at TDC.
What's
Now
your
the
We're
problem?
prosecution steps in, and their position is crystal clear. Maximum sentence under the agreement, 6 years. Why? Because from their perspective, this isn't just about punishing past behavior, it's about preventing future harm. They point out something very important. The defendant minimized responsibility until this very moment. And in court, timing matters. Taking responsibility late, especially after overwhelming evidence, is often seen as less genuine. The prosecution also emphasizes community safety. And that's the key word here. When someone repeatedly drives intoxicated, they're not just a danger to themselves, they're a danger to everyone on the road. So, let me ask you, should last-minute accountability reduce punishment? Or does it come too late when the pattern is already established? Because the state clearly believes it's too little, too late.
What's your
We're
problem?
recommending the cap, 6 years TDC, revocation. I'm sorry, 6 years TDC. I don't feel like safety is appropriate in this case. We're going to defer to you, of course, but that is the state's recommendation.
Fine. You heard what the state says, and this group of prosecutors has been very fair, I think. She's asking for 6 years in prison. Which- Um, the last time she was on probation, that's let me talk to everybody for just a second.
Yes, you know.
Yeah, Ms. Judice, you're a grown up and you can make that choice. The problem you have here is the way the
Here,
court.
the judge shuts down the defense's argument in a very logical and powerful way. He explains that giving a lighter sentence for repeated offenses would completely undermine the justice system. Think about that. If someone commits the same crime again and again, and receives less punishment each time, what message does that send? Exactly. It removes deterrence entirely. The judge even points out how dangerous that logic would be. It would encourage people to keep pushing boundaries because the consequences wouldn't escalate. And this is where the courtroom tone becomes final. The judge is no longer weighing options. He's reinforcing a principle. Actions have consequences, and repeated actions have greater consequences. So here's the question. Do you agree with this approach? Should penalties always increase with repeat offenses, that no matter the circumstances? Because this decision is about more than one defendant. It's about setting a standard.
The way the court feels like things ought to work and the way I do things is that you don't get lesser punishment for the same subsequent misbehavior, crimes. That would not deter crime. That would be working against deterrence. If people know the more they could get in trouble, the less punishment would be. They would just race to make punishments. So your cap is 6 years imprisonment. Anything to add by anybody else?
No, sir.
Anything from you, man?
Yes.
Okay, then I'm going to find, and I wish this didn't happen. You seem like a nice person, but we're talking about 4,000-pound missiles being driven around,
Yes,
and it's hard enough to drive them responsibly when you're sober. The way other people drive too.
Correct.
You got to be defensive. And again, this is your 5th DWI. You have been a felon three convictions ago. I'm going to find you have pleaded guilty in paragraph 1 and true to paragraph 2 in this third-degree felony of operating a motor vehicle while intoxicated. You have pleaded guilty and true to paragraphs 1 and 2 voluntarily, knowingly, intelligently. And you have pleaded true to the allegations in paragraph 2, which state that before you committed this offense, you were convicted of four previous DWIs, 2 of them being felony operating motor vehicles in public places, and you were sentenced to you were placed on probation last time. That was revoked, and you were sentenced to 5 years in prison. The agreement is a cap of 6 years in prison. I hereby find you guilty beyond a reasonable doubt of this third-degree felony. In paragraphs 1 and 2, I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years.
And just like that, the moment of truth arrives. 6 years, the maximum allowed under the agreement. But listen closely. It's not just the sentence that matters, it's the reasoning behind it. The judge emphasizes the danger, the repeated behavior, and the fact that this could have easily ended in tragedy. This wasn't luck. This was a series of close calls, and that's why the court steps in firmly here, not out of anger, but out of necessity. The judge even expresses disappointment, which tells you something important. This isn't about punishment for the sake of punishment. It's about consequences that match the risk involved. So let me ask you, do you think this sentence is justified? Or should the court have shown more leniency given her condition? Because once the sentence is handed down, there's no going back.
And I just wish we all weren't put in this position. I just wish you would fix this mess. But you have to know you are a blink of an eye from fatalities when you're operating a 4,000-pound missile, especially intoxicated. And not only you, but everybody else on the road relies on each other to act responsibly with 4,000-pound missiles zipping around the road. And for whatever reason, you did not learn from these prior convictions. And here we are, put into a situation where I'm disappointed, but this is the just result under these circumstances. All right, anything else?
No, yeah.
Okay.
Thank you.
Thank you. Good luck, man. Here is this.
Yeah.
Brandon Mingo. Brandon Mingo, that's Brooklyn Brewer.
I haven't seen the attorney yet this morning, Judge.
And Reagan.
This case is a powerful example of how the justice system handles repeat offenses, accountability, and public safety. We saw a defendant facing her 5th DWI, each one increasing the stakes, each one bringing her closer to a moment that could have ended in irreversible tragedy. The defense focused on health issues and leniency, while the prosecution focused on pattern behavior and risk to the community. And in the end, the judge made it clear. The law prioritizes safety over sympathy when repeated dangerous behavior is involved. The 6-year sentence wasn't just about punishment, it was about drawing a line that says repeated actions come with escalating consequences. Now we want to hear from you. Do you think the judge made the right call? Or should there have been more consideration for her personal circumstances? And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.